so today's class is form of a contract. We're going to begin with the statute of frauds and work through regulation of business. The good news is that you don't have to take a lot of notes today. Your handouts are very complete. All right, so let's begin with the statute of frauds. So I need you to remember that the statute of frauds does not require all contracts to be in writing. Only certain contracts have to be in writing in order to be enforced. So this is what the Virginia statute of frauds says. No action shall be brought in the following types of contracts unless the agreement or some memorandum or note thereof shall be in writing and signed by the party to be charged. All right, so in plain English, what does that mean? Let's take out the legalese. Certain contracts, not all, have to be in writing, and they have to be signed by the person against whom enforcement is sought. All right, so signed by the person being sued, in other words. So you need to remember that only certain contracts, not all, have to be in writing, and they must be signed by the party being sued. The writing does not have to be a document called the contract. It may be separate notes or memorandum. The writing simply has to identify the contracting parties and specify the essential terms. So what if you don't have a writing and you should have? So the effect of non-compliance is that the oral promise is not enforceable. So let's look at the types of contracts that need to be in writing to be enforceable. All right, so contracts that can't be performed within a year need to be in writing to be enforceable. All right, so contract and employment contract for 2 years. Let me give you an example of an instance where a contract should have been in writing and it wasn't, and the consequences thereof. This happened decades ago, and this example is loosely based, actually pretty closely based on a true story. So a little old man owned a business, and he wanted to sell his business, and his business also included a building. He wasn't quite sure whether he wanted to entirely retire, so he had an idea. He thought, well, what I will do is I will sell my business and sell the building, and then I have a back room in this building, and it has a separate entrance and a separate parking area, and I will frame pictures on the side, and that way it'll give me something to do. All right, so he negotiated the sale of his business and building, and in the negotiations he said that he would like to have a 3-year lease on that space I just told you about in the back of his building with a separate entrance. So the parties agreed to the lease and the sale, and the sale went through. At the closing, the little old man said, don't you think we should have a lease? Well, the attorney for the buyer said, oh, we're all gentlemen here, let's just shake on it. And they did. The little man is in his space, and I'll bet it wasn't 30 days later that he received an eviction notice. And he went back to the attorney and he said, well, I don't understand this. I have an eviction notice. We had an oral lease. Remember, it was a 3-year oral lease. The attorney for the buyer said, yep, and the statute of frauds says it should have been in writing. It wasn't, and so you need to get out of there. So from that example, here's what you need to remember. If the contract cannot be performed within a year, then get it in writing. An agreement to sell real property also should be in writing to be enforceable. Have I ever bought real estate under an oral contract? The answer is yes, I have. Do I recommend that you do that? No, absolutely not. The statute of frauds says agreements to sell real property need to be in writing to be enforceable. There is an exception to the rule. The exception is if the purchaser goes into possession of the property and either makes a down payment or makes substantial improvements to the property, then an oral contract may be enforced. Now, you certainly don't want to have to go to court to enforce anything. It takes a lot of time. It's expensive. So I'll give you an example of someone who entered into an oral contract to buy real property. It worked out in the end. In the meantime, it made me very nervous that she had done this. So a friend of mine entered into an oral contract to purchase a house. And she told me about the agreement to purchase the house. She was buying a house from an estate. And for whatever reason, she went into possession prior to closing, and she was going to purchase this property from an estate for $40,000. The closing wasn't to take place for almost a year later. So she's in possession of the property. She has this oral contract, and she made substantial improvements to the property. Now, that made me nervous, in part, because I thought, oh gosh, what if she has to sue to enforce this contract, this oral contract? She assured me that the people she was purchasing the house from were honest and ethical and nothing bad would happen. And indeed, spoiler alert, she was right. But let's say a year later, the representative of the estate comes into the house and says, wow, this house is not worth $40,000 now. It's worth $80,000. This looks great. We'll sell you the house for $80,000. Now, could my friend enforce the oral contract? And the answer is yes, because she went into possession and made significant improvements to the property under this oral contract. But again, you do not want to go to court to have to prove your real estate contract. So let's go into the assumption that an agreement to sell real property needs to be in writing to be enforceable. The promise to pay the debt of another person also needs to be in writing to be enforceable. So there's an exception to this rule too. So if I promise to pay your debt, so let's assume that you owe the Farmville Lumber Company $1,000. You were building loft beds for other students as they moved in, and you bought a bunch of lumber and you didn't pay for it. And you come to me and you say, I don't know what I'm going to do. The Farmville Lumber Company wants me to pay them $1,000. And I say, don't worry, I will pay your debt to the Farmville Lumber Company. And I go down and I orally tell them that I will pay your debt. I will be responsible for your debt if you don't pay it. Is that promise binding? And the answer, of course, is no, because it needs to be in writing. There is an exception, as I said before. Maybe in the law you'll get tired of hearing these exceptions, but the exception is the main purpose doctrine. Now, if my main purpose in promising to pay your debt is to benefit me, then an oral promise will be enforceable. All right, so let's say again you owe the Farmville Lumber Company $1,000. You have a contract on the side to build loft beds out at Hampton-Sydney, and that contract is for $2,000. And you just need to buy a little bit more lumber, and the Farmville Lumber Company will not sell it to you because you already owe them $1,000. Now, let's assume that you also owe me $300. You borrowed money from me earlier in the year, and so you owe me $300. All right, so you come to me and you say, gosh, Mrs. LaRoche, I can't pay you back that $300, but I do have a contract to build loft beds out at Hampton-Sydney, but I just need to buy some more wood, and the Farmville Lumber Company will not sell me any wood right now. If I can make those beds, you tell me, then I can pay you back that $300. So I feel sorry for you, and I say, okay, I'll tell you what, I'll go to the Farmville Lumber Company, and I will tell them that I will pay your debt if you don't pay it. And you say, oh, good. So I go to the Farmville Lumber Company. I agree orally to assume your debt if you do not pay it. Now, why did I do that? Well, I did that so you could build the loft beds out at Hampton-Sydney, so you could be paid $2,000, and you could pay me back the $300 that you owe me. You could pay the Farmville Lumber Company, and perhaps you'd have a little bit of profit. All right, so this is a promise to pay the debt of another person, but my main purpose in agreeing to pay your debt is to benefit me. So would an oral promise be enforceable? And the answer is yes. Now, similar to this is the contract of an executor. So the representative of someone's estate is an executor. So an executor of an estate is the person who gathers up all of your assets after you die and then distributes those assets according to the will. Well, an executor is the personal representative of an estate, and the executor's promise to pay the debt of the person who died, the decedent, must be in writing to be enforceable. All right, so we've almost gone through the list. The next bullet is promise in consideration of marriage. In other words, prenuptial agreements have to be in writing to be enforceable. Now, just a little bit of advice for you with prenups. If someone ever asks you to sign a prenuptial agreement, review it very carefully. This can waive your rights forever. So I would suggest that you negotiate with an attorney who deals with prenuptial agreements, someone who is perhaps even very familiar with family law, and have them review the prenuptial agreement before you sign it. Are all prenups a bad idea? No, not necessarily. But you should go into a prenuptial agreement with your eyes wide open. And then finally, this question will be on this test. It'll be on the next test and the test after that and the final exam. A contract for the sale of goods costing $500 or more must be in writing to be enforceable. Now, when we get to sales, we will talk about an exception to this rule. So sometimes courts do enforce contracts for the sale of goods that cost more than $500 if they are specially manufactured, that is to your specifications, and they may not be sold to anyone else. We'll talk about that exception when we get to sales next week. All right, so the parole evidence rule. The parole evidence rule says this, that when a contract is in writing, the general rule is that parole evidence or extrinsic evidence or outside oral evidence will not be allowed to contradict or to modify the terms of the written agreement. Now, I'll give you an example in just a minute. If a contract is ambiguous or unclear, then a court may allow parole evidence to clarify the terms of the contract. All right, so back to my parole evidence example. So again, if you have a written contract and it looks complete, the court is not going to listen to any oral evidence that modifies or contradicts the terms of the contract. Now, decades ago, a very good friend of mine was buying her first house. And she came to me. She worked in the courthouse, and she walked over to my office, and she said, "Oh, I'm buying a house." I said, "Oh, great, where is it?" And she told me where it was. And it was over in the Avenues. And then I said, "Well, gosh, can I see your contract?" And she showed me the contract, and I said, "Oh, you've signed it?" And she said, "Yes, I've already signed it." And I was a bit disappointed because it's always best not to sign a real estate contract until your attorney looks at it, because you may be able to renegotiate some of the provisions in the contract. At any rate, it was early on in my law practice, and I had a lot of time on my hands. And so I said, "Let's go look at the house." And we did. We drove over and we looked at the house. Now, when we got there, I saw that the standing seam tin roof was half painted. So it was half red, half green. And I said, "Well, what's up with this?" I'm going to call my friend Mary. I'll say, "Mary, what's up with the roof?" And it doesn't say anything in the contract that the owner's going to finish painting the roof. And she said, "Oh, he's honest and ethical, and he said he would, so I'm sure he will." And then I saw that the window sashes had been taken out. They were being reglazed, and the weights and ropes were being replaced. And I said, "So what about the windows? It doesn't say anything in the contract about the owner finishing the repair of the windows." And again, my friend Mary said, "Oh, well, don't worry. He said he would do that." Now, those are oral statements that contradict the written contract. Spoiler alert, I will tell you that my friend Mary was right. She was dealing with someone who is honest and ethical. In small towns, you often find that that is the case. And everything worked out just fine. So I'm going to change the example up. So let's say we get to closing, and the roof is half green, half red, and the windows have not been repaired. Would we be allowed to bring in parole evidence or oral evidence that he promised to do these repairs prior to closing? And the answer is no, we would not. All right, so now to my ambiguity example. So remember, if a contract is ambiguous, then the court may, not must, but may allow in parole evidence to clarify an ambiguity. All right, so I have two smart cars sitting in my driveway right now. One of them is blue, and the other one actually at this moment is black. I've changed the color of the smart car. You can change out panels on smart cars. All right, so you come over to my house this afternoon and you test drive the blue smart car. It's a little convertible. You test drive it and you say, oh, I'd love to buy it. And we enter into a written contract that says that I agree to sell you my smart car for $2,500. The contract does not specify which smart car, but you only test drove not the black one, but the blue one. And that's the one that we had talked about you're purchasing. Now, at this point, let's say that we've signed this contract and you are trying to enforce the written contract. Now, I have seller's remorse. I do not want to sell the little blue smart car. I raise the defense that the contract is too ambiguous to be enforced because we didn't specify which smart car I'm selling. Would the court allow the parole evidence that you came out to my house and you test drove the blue one and we talked about you purchasing the blue car? And the answer is yes, absolutely yes. All right, so effect of illegality. An illegal contract is void, and the courts will not aid either party pursuant to an illegal contract. So a gambling debt, for instance, would be part of an illegal contract. So let's say it's Thursday night. You come over to my house. We are playing poker, and we're gambling. And I very quickly lose all the cash that I have to you. So let's say I lose to you, I lose $200 to you right now. Now I'm ready to fold my cards and stop playing, and you say, no, let's keep on going. We will lend you $300 if you will give us an IOU. And so I write out an IOU. I owe you $300 and you allow me to continue to play with you. Now I also lose that $300. But you have a piece of paper that says, I owe you $300. Now, 2 weeks later, you come by my office and you say, Mrs. LaRoche, I'd like for you to pay me the $300 you owe me. And I say, no, I'm not going to pay you. And you sue me in General District Court here in Farmville for this debt. And I raise the defense of illegality, that this is a debt that's based on an illegal contract that is a gambling debt, and I'm not going to pay you. Also, I make a counterclaim, and I counterclaim for the $200 cash that I lost to you the night we were playing poker. Now, what will the court do? This is an illegal agreement. It's void without legal effect. Will the court make me pay you the $300, honor the IOU? The answer is no. Can I get my $200 cash back from you? The answer is no. The courts leave the parties where they find them. Good faith and fairness is something we'll discuss when we get to Article 2 of the Uniform Commercial Code next week, or sales. But here's the rule for you to remember. When there is grossly disproportionate bargaining power, the courts may come to the aid of the weaker party. And we see in Article 2 of the Uniform Commercial Code courts applying this notion of good faith and fairness. Marshall versus Mercury Finance Company. This is an interesting case, and Marshall purchased a used 1980 BMW from B&B Sports Cars. The amount that was financed was $5,455. The interest rate, now get this, is 29.48%. Marshall challenged the validity of the contract, alleging that it was unconscionable. It is unconscionable, right? That's an incredible, that is incredible interest rate. Marshall testified in court that he had a college degree. Not only did he have a college degree, he was a business major, and that he could read and understand the documents in question, and that he was just behind in his payments. He asked the court to declare this contract null and void. Is this unconscionable? The answer is no, this is an enforceable agreement, because here we did not have grossly disproportionate bargaining power. In fact, Marshall knew what he had signed, and so he's going to be bound by the terms in the contract. Now, let's compare that case to Perkins versus Standard Oil. Mr. Perkins had an agreement with Standard Oil, and he only sold Standard Oil's products. Perkins was obliged to make substantial investments in storage facilities, delivery trucks, and other equipment. And again, as I said, he was only allowed to sell Standard's products. And his compensation was based exclusively on the sales that he made to his customers. Here's what happened to poor little Mr. Perkins. Mr. Standard Oil, huge corporate giant Standard Oil, sold products directly to Mr. Perkins' customers. In other words, they stole Mr. Perkins' customers, cutting him out. Mr. Perkins asked the court to imply a protective term to his contract with Standard Oil, protecting him from Standard taking Perkins' customers. In this case, since there was grossly disproportionate bargaining power, then the court did apply a protective term to Mr. Perkins' contract. Agreements affecting public welfare. Now, with agreements to protecting public welfare, you could have a situation where a contract evades an existing statute. And contracts that evade statutes have not been enforced. Contracts obstructing justice, likewise, are enforceable. So, Bovard versus American Horse Enterprises is an interesting case. In the Bovard versus American Horse Enterprises case, the defendant purchased a company from the plaintiff, and the defendant signed some promissory notes payable to the plaintiff. The promissory notes were not enforced, were not paid, and the plaintiff then sued to enforce these notes. All right, so American Horse Enterprises, among other things, mostly what they did was they manufactured rolling papers. So this is a case out of California. It's an older case. They manufactured rolling papers, and American Horse Enterprises also manufactured bongs and paraphernalia for smoking marijuana. They manufactured a little bit of jewelry, but mostly just rolling papers and bongs. Now, the judge, on his own, looked at this case and said, you know, it is illegal to sell marijuana in the state of California. So this was before even medical marijuana was allowed in California. So the judge said it's illegal to sell marijuana for anything, for any purpose in California. And since it's illegal to sell marijuana, the judge then on his own said this contract evades an existing statute, and thus it is illegal and unenforceable. And so that's exactly what the court held, that the court refused to enforce this contract for public policy reasons. So let's look at another case, and this case is perhaps a little bit closer to home. This case is from North Carolina. And so in this case, Mr. Coates, the credit manager, embezzled $54,000 from Smithfield Ford. That's Mr. Jones. Adams, those are the parents of Coates, went down to the owner of Smithfield Ford and said, oh, please do not criminally prosecute Junior. We will pay you back all the money that he embezzled from you. We do not want him to go to prison. So the Adams made a $10,000 in payments, and then they stopped. Now, we can only speculate why they stopped. My guess is Junior probably did something else that annoyed them. So they said, we're not going to pay anymore. Now, the owner of Smithfield Ford really didn't care. The owner simply wanted his money back. And so the owner of Smithfield Ford then sued the parents to enforce the original contract. Is it enforceable? The answer is no. The court held that the well-settled law in the state of North Carolina is that executory agreements, remember executory agreements are ones that have not been fully enforced, fully performed. Executory agreements made in consideration of preventing, refraining, or suppressing prosecution of a crime are void and thus against public policy. So the owner of Smithfield Ford, in this case, was out of luck. Lottery. Elements of a lottery are prize, chance, consideration. So here's the deal. If you're giving away a prize, and it's strictly by chance that the winner is going to win that prize, and there's consideration, in other words, you have to pay to play, then in Virginia, you must have a license to have that lottery. There's some exceptions if you're a charitable organization, but the general rule is that you must have a license. Now, that's the law in Virginia. So the elements of a lottery are prize, chance, consideration. So let's say your sorority is raffling off a TV, and you're selling tickets to have a chance to win that TV, and the way you're going to choose the winner is you're going to pull the name out of a fishbowl. Then that would be a lottery. Now, let's look at a real case. And the case is Grove versus Charbonneau Pontiac. Now, there's an annual Labor Day golf tournament. And at this annual Labor Day golf tournament, it was being played on a 9-hole course. And there was an offer made. And here's the offer, that anyone who made a hole-in-one on hole number 8 would win a new car. Now, Mr. Grove entered the golf tournament. Did he have to pay to enter the golf tournament? Yes. So is there consideration? Yes. Are they giving away a prize in this case? Yes, perhaps a new car if you make a hole-in-one on the hole number 8. Now, Mr. Grove, on the first day of the tournament, as he's playing hole number 8 as the 8th hole, he did not make a hole-in-one. In fact, no one made a hole-in-one. On the second day, when Mr. Grove was now on the 17th hole, now physically, since this is just a 9-hole golf course, it is the 8th hole. So on the second day, when hole number 8 was being played as the 17th hole, Mr. Grove made a hole-in-one and he demanded the new car. Now, the question for the court is, does he get one? So let's look at a few issues here in this case. Now, first question, is this a unilateral contract or a bilateral contract? And the answer is, it's a unilateral contract. So how does Mr. Grove win the new car? How does he accept the offer? He makes a hole-in-one, so it's a unilateral contract. Remember, reward cases are examples of unilateral contracts. Now, the second question is this illegal as a lottery? All right, so are they giving away a prize? Yes. Is there consideration? In other words, do you have to pay to play? Yes. And then how about this? Chance. Is it strictly by chance that you're going to win that new car? So the court did a balancing test, and the judge said, you know, making a hole-in-one is partly chance and it's partly skill. But the judge said, in the overall scheme of things, I believe that there is more skill than chance in making a hole-in-one. So if there's more skill than chance in making a hole-in-one, is this an illegal lottery? And the answer is no, it is not. Now, what about the rules of construction? In any contract, there are rules of construction that must be followed, particularly if a contract is challenged. The first rule is that ordinary words are given their ordinary meaning. The second rule is this: a contract is strictly construed or strictly interpreted against the person who wrote it. And here, did Mr. Grove write the contract? No, he did not. the sponsors of the golf tournament wrote the contract. So when on its face, it does not appear that the offer is ambiguous. But when applied to the facts of the case, the offer is ambiguous. It's a 9-hole golf course. They're playing 18 holes. So does Mr. Grove win the new car? And the answer is yes, Mr. Grove won the new car. Now, the court held that there was an ambiguity, and since on the second day, the 17th hole was the same tee that they'd used for hole number 8 on the day before, that Mr. Grove wins the new car. All right, so now moving forward, you are writing the offer. Let's say you're going to sponsor the Labor Day golf tournament again next year and you want to give away a new car. How are you going to write that offer? All right, so I suspect that what you'll do is you'll say that, you'll specify that the hole-in-one on hole number 8 is only on the first day of play when the 8th hole is being played as hole number 8. All right, regulation of business is the last topic of the day. And so laws frequently require that a person obtain a license or a certificate or a diploma before operating a business. So, and if this requirement is to protect the public, so a lawyer, for instance, passing the bar examination in Virginia, then a contract made by an unlicensed person would be unenforceable. An unlicensed person may collect on a contract if the license was required only to raise money for a locality. So that would be Farmville business license. All right, so let's assume I have passed the Virginia State Bar, by the way. I am only an associate member right now. I don't have malpractice insurance, and to be an active member of the bar, you must have malpractice insurance. Anyway, yes, I passed the bar decades ago. Let's assume that I never passed the Virginia bar, and I'm practicing law in Farmville as a lawyer, and you come into my office, and I do a real estate closing for you. I do everything just right. I don't make any errors. You find out that I lied about passing the Virginia bar exam, and now you don't want to pay me. Do you owe me the fee? And the answer would be no, because the licensing requirement, the requirement of passing the Virginia bar is to protect the public. Now, what if instead I'm a member of the Virginia State Bar, I'm an active member in good standing, and I'm practicing law in Farmville, but I do not have a Farmville business license. Now, the purpose of the business license in Farmville is to raise revenue for the town. Again, I do the closing for you. I do not make any errors, and you find out I have not paid my business license now, and you do not want to pay me my proper fee. Do you have to pay me? And the answer is yes, you do. So if the unlicensed person is trying to collect on a contract and the license is only required to raise money for a locality, then the contract is enforceable. Now, when we get to employment, we'll talk about this again, but agreements not to compete are often included in employment contracts, and they may also be included with the sale of a business. So in other words, you go to work for an accounting firm and you agree that if you leave the accounting firm, that you will not practice as an accountant for 2 years within a 25-mile radius. That would be an agreement not to compete. Now, this is enforceable. In Virginia, agreements not to compete are enforceable if they are used in connection with the sale of a business or an employment contract. However, the agreement has to be limited both in terms of scope and duration. Years ago, I had a doctor call me up. He was an ER doc. And he said, I'd like to leave this company that I'm working for. And I said, so what's stopping you? He said, an agreement not to compete. And I said, well, read it to me. And this is what he said. It said that if I leave this company, that I can't practice as a physician within the Commonwealth of Virginia for 10 years. I said, oh, go ahead and work for whomever you want. He said, well, why? I don't want to be dragged into court. I said, because that agreement not to compete is too broad. It's too broad in terms of geographic scope. It's too long in terms of duration. In Virginia, here's the rule that we follow, that if an agreement not to compete is overly broad, that the courts throw it out altogether. They don't rewrite it, they throw it out. Now in some states, these agreements are rewritten. So Massachusetts, for instance, the courts will use what's known as the blue pencil rule or the red pencil rule and rewrite these agreements not to compete, but not in Virginia. If they're overly broad, the courts throw them out. So next class is discharge of contracts, and we will also begin sales. And you take care and have a nice weekend. Thank you.